Good afternoon, everybody. So this is our third and final part of this training. And in the prior parts, we talked about the basics of town government and how you fit into the state government, the federal government, and all that, how the powers are split between voters and the board and some of the powers they share. We talked about where the powers come from in statute. The second part focused on the open meeting law and the conflict of interest issues that come up. So as we talked about in both of those parts, the rules we're discussing are based on public trust. So the things we talk about today and in those prior parts are all there to keep the public trust in government. And we want to keep that in mind as we move on. Okay. So picking up on contracting, it wasn't conflicts, it was contracting in the second part. What do you do when you want something your township has? So occasionally you may be in a situation where the township has a piece of equipment or something and they want to get rid of it, and you may be interested in that item. So in that case, we are subject to some rules here. Okay, no officer or employee shall sell to any officer or employee any property owned by the municipality except by these specific conditions. Okay. So we start with that general rule, and I read it because if you read that closely, it says it's selling. That's the problem. It's not buying. That's the problem. So if your township has something, basically it's on the Board of Supervisors there to ensure that it does not go to any officer or employee. All right, and that's under any condition there as far as the officer. Now, there is an exception for people who are employees. If you're an employee, you may be able to get your township stuff. Okay? If that's of interest to someone, what they would do is they need to have the board look at taking either a sealed bid or some kind of auction, and so that that employee is treated the same as everyone else and is given equal opportunity. Okay? So for a board, if they want to do that, they should ensure the process they use is designed to get the word out that this piece of property is available, and the conditions for bidding on it. Now that may be sealed bid, which, as we talked about in the last part, has a lot of hoops to jump through. Okay, it's also possible to do an auction. All right, that is a little easier. It's important that you do that though for that employee, because again, we go back to the first part. It's important that they don't sell, okay? So I guess we could take from this, if you want to get your town board in trouble, maybe they don't know this rule, get them to sell you something, right? Because they'll have the issue, it's not the buyer. But no matter what, whether there's a legal penalty or not, everybody looks like they have violated that public trust. It's an appearance of impropriety, okay, for that employee if we don't go through that process. But now look at the bottom here, okay? A person violating this rule is guilty of a misdemeanor, all right? So misdemeanors up to 90 days in jail and a $1,000 fine. And now there's no circumstance under this rule for an officer to get any township stuff. You just can't have it. That's difficult for folks sometimes. There's a case that the state auditor looked at years ago, in which the township had an old pull-behind style grader. It wasn't going to be used by anyone. It was scrap, really. They had tried to sell it. No one would take it. They could junk it, but they weren't going to get anything for it. Well, one of the supervisors felt that it was important to keep this. This was a piece of town history to him, and so he bought it. And he put it on his property as kind of this little monument of the township history. Well, somebody saw that grader and said, well, wait a minute, that belonged to the township. How did that get to this officer? That's not right. That feels like self-dealing. And so, remember, we talked earlier about if you see, as an officer, theft, embezzlement, or misuse of funds, you're required to report that. Okay? Now, if an officer had seen it, they should report it. But in this case, it was a resident that saw it and reported it, and there was an investigation from the sheriff, and there was an investigation from the state auditor. And a report came out, and it named all the names, and it explained this rule that you just heard about. And it concluded they did something wrong. This was not legal. Now, the person who bought it isn't the one who did the illegal act. It was the supervisors who sold it. All right, so be cautious when selling that stuff. The standard question that would come up if we were in the in-person setting is, well, what if my spouse buys it? Okay, so somebody thinks they're a criminal mastermind and they're going to defeat this rule. Well, that's been tried. It doesn't work, okay? As a matter of law, your spouse and you, the things you acquire during a marriage, are jointly owned, okay? Well, what about my kid? Well, if they're in the same household, no, chances are that's still considered shared ownership. What about my kid who doesn't live with me? They're an adult. I'm not going to get the benefit of it. What about my brother who buys it and maybe I get it later? All those things are bad ideas, okay? Even if to the letter of the law, the town board could sell to your brother or to your kid. If that ends up back with you, it's going to look like that was set up all along, okay? You want to maintain public trust. Please follow this rule. There's nothing your township has that is worth your credibility and their good feeling about who you are, okay? So we'll just as a rule, as an officer, even if you're an appointed clerk or treasurer, you will not get your township stuff, okay? All right, that moves us into conflicts of interest, all right? Conflicts of interest is kind of a big topic, so we're going to be here a little bit. We'll have different slides, but it's a big topic to deal with, and it's because there's two types we have to deal with. There's common law, and there's statutory. And they both have some things in common, but they differ in how they apply. Both of them require a personal financial interest in the outcome of a vote or in something going on the board. Okay, so this is an individual problem. So if a supervisor, for example, has a personal financial interest, then that could be a conflict of interest we have to deal with. Now, sometimes you're going to be able to participate. You're going to be able to have the conflict. There's ways to cure them. But you certainly need to be aware of them to even approach the steps where you could fix them. All right? The statutory type of conflict of interest is all about contracts. Okay? There has to be some kind of an arrangement, some agreement or contract, whether it's written, verbal, an understanding, course of conduct, something that says we have an understanding between the parties involved here. Okay, and the common law type is for non-contract situations, something that is probably just a vote on the board, but it doesn't have a contract component to it. Okay, now when we say personal financial interest, we break that apart a little bit. Personal means personal to the officer. Okay, so it is individualized. It's let's say you're going to vote on how to spend money on the town roads. Well, the supervisors, of course, have a personal interest to some extent about how their tax money is spent because, of course, they're paying taxes too. But that's not a personal financial interest. Everybody shares that, okay? We're trying to find something that's more particular to them or a subgroup, all right? So a special assessment that's going to be on that officer's property, yeah, that's a problem. They're going to be charged something, so there's a personal financial harm. Or if there's going to be an improvement and their property is going to be worth more, well, that's a financial gain. Either way, that's personal to them and their property. Okay, so that's what we're looking for, and it has to be financial. So there's some things people look at and they say, well, that doesn't look right. But if there's not a financial benefit or loss involved to that officer, it's not a conflict of interest. It might be something else. It might be an appearance of impropriety. Okay, but not a conflict of interest. So we'll get into these two types. All right, two types. Let me get back here. The first one is more complicated to understand up front. The common law type, again, this is non-contract type, so you have some decision on the board that could have a personal financial outcome on a board member. Okay, and the difficulty is there is no statute. Common law is judge-made law. It's made in courts because there's some problem and there's not a statute, or there's holes in a statute. All right? So, for example, we have a statute for conflict of interest, but it only deals with contracts. Well, disputes come up where people bring a problem to a court, and a judge says, yeah, there is an issue here. This cannot stand the way it is. We cannot keep trust in government if we allowed this. So they come up with common law rules about this. So these factors you see, we're going to break these down, but this comes from court cases. It's not recognized in statute. The legislature would be aware of that at this point. This has been around a long time. All right, we're going to do this with an example, a real-world example. Township in southern Minnesota, they have a 3-person board, okay, and they do some liquor licensing for a bar. And this bar opens up, and they want a liquor license. Well, the first year the county grants it erroneously because the county didn't realize they had to come to the township to get approval. Okay, so the bar's been operating, and it's successful. Well, by the second year, the county realizes that they should have gone to the township first, and they do that next year. This is controversial in the township because some folks don't like that there's now a bar in an area that used to be residential or farmland, or some just didn't want it there. So it was a packed meeting, people for and against this operation, and one gentleman who lived across the street from the bar, across the road, said, my property has been reduced, the value, by at least $60,000 by that bar being there. Do not issue them the license. Let's get them out of here and they can go somewhere else. Well, the town supervisors felt that this bar had been operating for over a year. They were now established. They were doing well, and it was something new in the community. So they granted it. Now, the following year, that liquor license has to come up for vote again, right? But in between that time, there's a vacancy on the town board. And, of course, who gets elected? That guy across the street who's very upset about the bar. So this year, the bar is again applying for their license. 3-supervisor board, and that new supervisor convinces one other person to vote along with him to deny the liquor license this year. So now the bar is out of luck, and they face losing their business. So of course they sue the township, and here that is the appropriate action. Okay, they say that supervisor had a common law conflict of interest in the outcome of the vote. He's said that he loses money or value because of it. Okay, and so the court would take this and they'd look at these and look at the factors. The first factor is, what's the nature of the decision? This is not really a helpful issue, okay? This is, well, what are we trying to figure out? Is this a taxing issue? Is this a regulatory issue? Is this planning and zoning? Is this, and in this case, it's a permit application. So the board is sitting not as a legislative body as you usually are, but they're sitting almost as like a court, okay, deciding on whether this particular applicant is going to get something. And it's not a broad direct impact to everybody in the community. Okay, it's that one applicant that they're deciding on, and that just kind of sets the stage. Okay. 2, what's the nature of the financial interest? All right. In other words, is there a financial interest from the standpoint of that one supervisor who lived across the road from the bar? Now, people could differ about this. For example, we don't actually know if his value, property value, was decreased, and there's good reason to think it wasn't, and maybe it was even enhanced. Who knows? But the fact that he said, I lost value, says he believes that is the case, at least enough to represent that in an open meeting of the town. So in other words, do we have a financial interest? Yes, and that's what the court found. Okay. Now then we go to number 3 here. What's the number of interested officials? On this board, there's only one interested official. Okay, and that brings us to number 4. Do we need that interested official just to get a quorum so we can make a decision? Remember, you must have a quorum no matter what of your board. That board acts as a group. There's no individual that has individual authority. Not the chair, not any other supervisor. So here, we only have one person interested, and we have 2 remaining supervisors. They form a quorum, and they may vote. And remember, there's no tiebreaker here. Okay, there's no clerk gets to step in, no tiebreaker. Okay, and then last, is there any other means to ensure public interest? Is there a backstop? Okay, that's the idea. If it's a planning commission and they make a bad decision, well, there's a backstop. It goes before the town board. Okay, if the town board makes it a bad decision, is there a right to appeal to a court? Okay, these all may help the issue. Okay, but the court looks at those factors and those in that fact pattern I gave you, and they say yes, there was a financial interest. He said so. 2, there's only one person interested. That leaves 2 who can make the decision. This supervisor should have abstained. He had no reason to participate, just so they could get a quorum to do business, okay? And you don't need him to participate to get the vote. Now you may be thinking, but that leaves 1-to-1, right? That leaves a deadlock, and that's okay. We live with deadlock sometimes. It just means that the town didn't produce an answer. Really, it means that it would fail, but the way that liquor law works is that it then returns to the county for the county to make a decision. So the result would have actually been different because the county was going to approve it. And that brings us to our last point on this, okay? If the decision, let's say all 3 had voted the same way, okay, on that fact pattern we gave. If the decision's still the same, and we would have thrown out that bad vote, well, the court says, yeah, it was a conflict, but nothing changes. The applicant, the plaintiff wasn't harmed, because even if we take that person out, there's still a majority to make that thing happen, okay? The very simple way to fix a common law conflict of interest, don't vote. That is all. You just don't vote, and you have cured your conflict of interest. So you get up from the council table, from the board table, sit in the gallery if there's an audience, okay? Make it clear, physically, you are not participating as a board member, not in the discussion, not in the vote. Now, if they have public comment, you, of course, could participate like the public, just not in your role as a supervisor, okay? Let's change the facts a little to show how this can be different. A different case. This is it's called the Coon Creek case, and it's a watershed district. It's not a township, but they do have 5 supervisors, okay, in this watershed district. They are building a big improvement along the watershed, and 4 out of 5 of the district commissioners here, the board members, live right on the watershed. They're right on the water course. So they're considering this, and it would be a substantial tax increase. Well, they pass it, and somebody who's upset with this plan brings them to court and says, you 4 had a common law conflict of interest. You had a financial benefit because your properties are going to get reduced flooding, and that was the goal of this whole project. Reduce the flooding, the seasonal flooding on these properties in the watershed. Okay, so it goes to court, and the court looks at it and says, well, it's not an application decision like we had in the other one, okay? This is a general policy decision. Are we going to do this project for a wide area? Of course it mostly affects those who live right on the watershed. There's benefits to others, but those right on the water course are most affected, okay? Is there a financial interest? Number 2, is there financial interest? Yes, there is. Again, we could differ about that, but chances are, if you're going to have reduced flooding, your property value probably increases, okay? Or it's better off in some way. So we say, yeah, there's a financial interest. Number of interested officials, 4 out of 5 are interested. Well, if all 4 abstain, we no longer have a quorum. That board is rendered completely ineffective, and they can't do any business. And that's where the court says, well, we needed some of them. In number 4, we needed at least 2 of them to stay so that we have a quorum of 3 on our board here, and they could do something. Okay? And number 5 wasn't really a factor in this one. Now that set of situations, set of facts there, produces a completely different outcome. The court in that case says, all 4 of them get to vote and participate. We recognize they have a financial interest. We believe they do. But frankly, we need them because there's no one to step in for them. And we can't just render the government body ineffective and unable to do its basic business, and this was its basic business. Okay, so little differences in fact make this a hard problem to solve, and that's why when you get one of these, call us and we will try to help you. Okay, we'll walk through these with you. All right, on to statutory, which is much easier to understand. Okay, there's a little paperwork involved we'll get to, but much easier to understand in general. So here's the rule. Okay, right in statute, a public officer, meaning any of you, supervisor, clerk, or treasurer. Okay, and I'm sorry, I didn't mention, in the common law type, it requires a vote. So clerks and treasurers, you cannot have a common law conflict if you don't have a vote, right? Well, here now in statutory, you might, okay? And it's because it says a officer authorized to take part in any manner in making a sale, lease, or contract in official capacity shall not voluntarily have a personal financial interest in that contract, okay? You can't benefit from. And now we're upping the stakes. If you violate, now it's a crime. It's a gross misdemeanor. On the common law type, wasn't labeled as a crime. There might be a civil issue, but it's not a crime. And gross misdemeanor is getting more serious. That's up to a year in jail and up to a $3,000 fine. Okay? Now, if you had one of these, the county attorney and state auditor, they can't look the other way or something. This is considered a serious problem. Okay? So we do have to pay attention to it. Now, we're going to be able to fix it, though. Okay? So any public official, that means all of you have to take notice of this. And it's because even the clerk and the treasurer could have taken part in a sale, lease, or contract in some way. Okay? And there's not any case law anywhere interpreting that language you see to say, this means supervisors. This means people with a voting interest. So the cautious approach to take is to assume that any one of you could be subject to this. All right? And unlike common law, where all you had to do is abstain and you fixed your issue, that is not so here. You could be in Florida on vacation, and if they vote to award you a contract or vote to give you some benefit, okay, that's a conflict of interest, even though you may not have realized it was going on. Okay, now we'd have an argument about whether it was voluntary. Okay, but that's why it's important that we fix these, all right, with one of the exceptions. And you see the statute there, 471.87 is that general rule. Okay, I believe it's .88 that has maybe 14 exceptions. There's a ton of them in there, right? But the one that's really important is that if it doesn't require sealed bidding for the township, which is a contract over $175,000, so if it's under that, it's possible the township could award that contract or that arrangement to a town officer. But we have to do something to fix it, okay? And it comes down to two pieces of paper. These two pieces of paper they basically say the same thing, okay? The first one is the town board resolution that says, we recognize this is a conflict of interest to do this, but we think it's a fair price, it's the right thing to do here, and we're acknowledging it, okay? So they pass their resolution before the contract is awarded. That's step one. And then they award their contract, and the person does the work. And then when that officer goes to make a claim for payment, they produce an affidavit that says basically the same thing. This is a conflict of interest. I did the work. It was at a fair price. We're disclosing it under this exception. Please pay me. So two pieces of paper fixes this, okay? Now that resolution, the resolution doesn't have an expiration in law, but we recommend every township do these every year at the reorganization meeting. And we recommend every township officer get one that is generic, okay? Because you have activities you do that are your elected duties. Supervisors, you go vote, you talk to constituents, you go to trainings, you go out and examine things, you manage employees, you have administrative tasks that you do. That's all part of your elected function, right? But no part of elected office is to pick up a shovel and dig out a culvert, to shovel the walkway at the town hall, to operate the plow or the grader, or to serve as an election judge. You may do those things, and it's so common for township officers, okay? You guys do real work. You get a county commissioner, okay? Let's say the county has a problem in a ditch. Well, somebody calls the county commissioner, who calls the supervisor at the county offices, who calls a manager, who calls a line worker to go fix it. Well, in a township, you guys get the call, and you go out and dig this thing out, and you fix it. The operator isn't available, you get in the truck and do it. Great, that's okay. But these two pieces of paper are important, okay? One resolution per year at the reorg meeting, and it's going to be a generic one that says this person is allowed to do operating duties as needed, election judge duties as needed, and manual labor as needed. And if there's anything else you do that's outside of your normal work, add that in there, okay? You abstain from that part of the vote. The other supervisors, if you're a supervisor, you don't vote, they pass it. You step back in to pass them for the rest. Clerks and treasurers, I recommend you get these too. Okay, now when you do that work, you put it on your claim form, in the month, turn in your affidavit. And you do an affidavit every time you make claim for payment for those extra things. Okay, so if there's a month where supervisors, you just go to a meeting and do your administrative tasks, that's not what we're talking about. You don't need an affidavit for that. Okay, but if you get in the truck and you operate, or you dig something out, or you're doing that stuff, now you turn in that affidavit. And what I recommend you do is use the sample forms we have prepared for you to make this as easy as possible. It is document C6000, okay, Charlie 6000 on our information library on our webpage. That is probably one of our most downloaded documents because everybody needs it, all right? It has a sample resolution, one resolution for each person. You can't just do one for the whole board. I'm sorry. We can't be that efficient here. And then a affidavit for each person. Okay, I recommend you fill in most of the affidavit and then leave the bottom blank for when you need to sign and date each time. Okay, make yourself copies. It's simple. I know it can be frustrating, but this will save you a problem. Okay. If you didn't do this, okay, we've talked before about when does this become a problem? It's when somebody's mad at you. The town board refuses to give someone a second driveway approach. You won't give them the land use request that they wanted, or you allowed somebody else to get something they wanted. Or maybe you don't even do land use and they're just upset at the county and that you didn't do something. Okay, it doesn't even have to be fair. But they're looking for something to ding you on. And they know that you shovel the walk for extra money and you operate and you serve as an election judge, and none of that's an elected duty. And they say, I don't think you should be getting money for that. That's a conflict of interest. So they call. They call the local paper, and they call the sheriff, and they call the state auditor. And what happens? Well, the state auditor gets the report, and their function is to investigate. And they will. Okay? They will call down to your township, and they'll get the clerk probably. And they'll say, okay, we just had this complaint. I'm very sorry. You know, I don't think this will come to anything, but I need your conflict of interest waivers. And I'm hoping you'll say, yeah, I'll get them right up to you. But some townships are going to say, what are you talking about? And that's where we're going to start to have a problem, okay? Because the letter of the law requires this. And what they'll do is produce a report, okay? And that report goes to the county attorney for possible prosecution. But it also gets put on the state auditor's website to live there forever for me to provide examples of don't do this, okay? And the local paper gets a hold of that. And sometimes they struggle to find things to write about, right? So they're going to grab that. Corruption in the local township, and there's going to be your picture with the report and quotes about what you did wrong. Okay? You don't want that? I'm sure. Please use these simple forms to resolve this problem. Okay? And then we won't have to deal with it. Or you'll be able to deal with it very quickly by showing your resolutions. Okay? So question, resolution annually per supervisor? Yes, we recommend resolution every year for each person, not just supervisors, okay? Clerks, treasurers, what if you draft a contract? What if you participate in the negotiation? That statute you have on that slide says participate in any manner. Okay, that's really broad language. And you can bet that a court is going to look at this and say, we're going to interpret this in favor of the public interest and the public trust. Okay? So not just supervisors, clerks, and treasurers too. Okay? Good question. All right. Again, C6000. Please go grab it. Okay. All right. Liability. Liability, the scary stuff. I know I've talked about a few things that can get you in trouble, okay? A few crimes and stuff, but that's not usually what we have to deal with, all right? What we usually have to deal with are, for municipal liability, procedural and decision-making claims, or property damage and personal injury, right? These are civil things, okay? Now, it's important to understand when these things happen, they're a town problem, okay? And what you should have is an insurance entity standing behind you, okay? And what you'll get, for example, a procedural decision-making claim. These are, somebody says there is a road in front of their property, and you don't, as a township, believe you either have a road or you may, but you can't do anything about it because one of the rules that affects town roads, okay? They're upset about it. They don't want the road or they do want the road, and your township either disagrees or says, look, we can't do anything right now, okay? Well, they may say, we're going to take you to court. We don't think you've made the right decision on this thing, okay? Or I wanted a driveway approach and you didn't even give me a hearing. You took my trees out of my right-of-way. Well, yeah, it's in the right-of-way, but you had to give them written notice and time to demand a hearing. If you didn't, they have a procedural or decision-making claim, okay? And remember that in Part 1, every power you have has to come from a statute. Some statutes give you procedures, And if we skip a step, it's like you didn't follow the law at all. You didn't have the power. Okay? So when we have a question about, do we have this power, you find out, especially as you're a new supervisor, okay, or clerk or treasurer. Call us, call your town attorney, talk to somebody, okay? Please don't take well, we've always done it that way, okay? I got a lawsuit coming in a western Minnesota township because they did their tree management the way they've always done it, okay? And unfortunately, something went wrong, okay? These things come up. So we try to find the right answers, use the resources online or off, and then we follow each of those steps. Okay, like when you create a road or get rid of a township road, a vacate, okay, we have a resource that gives you a checklist. Do all these things. Okay, now we've probably gotten rid of the procedural decision-making claim. All right. The other one can be property damage or personal injury. The grader or the plow, most often it's the plow. The plow hit my mailbox. The plow struck my vehicle as we were going by. A slip and fall. I was going into the town hall and I slipped and fell. I was using the recycling facility or the garbage facility at the town hall and I slipped on the ice. Okay, these come into play, all right? Trespass is one which can be related to the roads. If you went over your right of way, you may have a trespass problem, okay? Water issues. You allowed water or stopped water in a way that somebody's upset about, and the law says water is a common enemy. It says, okay, everybody's got a problem with water somewhere along the way. But it's always got to get from high ground to the low ground, okay? So you always run into issues with this, and sometimes they'll claim you did a taking. You did something that took my property, okay? Or you damaged me in some way. So we watch out for those things, all right? And those are all municipal problems, problems of the township itself, okay? Employees. We have to be aware of employees. If you have employees, you have to follow employment-related laws, and those are watched, and there's entities, both state and federal, resources for employees to protect them, okay? So if you have employees, or if you're going to get them, use the resources available to make sure you're treating them well and giving them all the rights they're entitled to, okay? Understand how to manage them. When we do finally get back in person, we'll have harassment training for supervisors and probably clerks and treasurers as well, because that's an issue that's only growing in concern and growing in number of cases, okay? So that's municipal liability. They're not crimes, they're civil actions, all right? Now, we move on to personal liability, okay? Now, who would take this job if you were personally liable for that flooding caused by some change in the culvert or by weather-related issues or denying an access point on the road or not taking out a road or putting one in, or you've got a contractor and they hit somebody's vehicle? Nobody would do this job if you had personal responsibility for those things, and you don't for those kinds of issues, okay? Those are civil liabilities on the township itself, and there's a statute that says even if, for some reason, you are named in a lawsuit, your municipality has to indemnify and defend you, okay? But these are for civil issues, all right? Now, how can this happen? You're at home enjoying a beverage, maybe on a day like yesterday, not so much today, but yesterday, and there's a knock at the door, and you get it, and there's somebody standing there, and you say, hello, well, how are you today? I'm great, and here, you've been served. And there it is in black and white. On the top of that document is your name. Along with the township, you have done something wrong and you are being sued, okay? And you walk back to your significant other who, your mouth is hanging open and they're saying, what's going on? And you hand them the paper. And they say, you dummy, I knew you shouldn't have gotten yourself into this. You didn't even want the job. They wrote you in. Well, don't worry, okay? That's the moment you remember this. And remember that for civil actions, okay, you don't have personal responsibility. What that probably was is an attorney who wanted to ruin your day, okay? They're horrible, awful people. We're trained that way, okay? And so what they're really trying to do is get you afraid probably and get you on the phone to say something you shouldn't. But don't do that, okay? Because your name should get removed from there and oftentimes we can get it removed. But instead, what you do is you report it to your insurer, and for most of you, the insurance company is MATIT, the Minnesota Association of Townships Insurance Trust, a separate entity, but they are managed through the MAT office. What we do is assign a counsel for you, for your township, okay, if it's covered, and then that person works to protect the township and you, okay? But if for some reason you remain, you get indemnity for these things, okay, because it shouldn't have been your issue. You as a board are acting on behalf of the township with the public's trust. You don't have personal liability, all right? When you have criminal complaints, you do have personal liability, all right? And the open meeting law is kind of a weird one. That's where it's civil, but there's that personal fine that we talked about. That's kind of an exception, okay? It's not a crime, but you do have some personal skin in the game on that one. All right, criminal liability, yeah, that's on the individual. And it's because it wouldn't be in the public's interest to defend or pay for criminal defense, because if that person's convicted, it's saying they're a criminal, and we don't want tax money going to protect a criminal except for a public defender, where we've acknowledged as a constitutional issue, everybody gets that, okay? But the township can't pay for your criminal law defense. They can't indemnify you if you have a fine. And we talked about the places you could run into that, okay? Conflict of interest today. We talked about that on the statutory type, that's a gross misdemeanor. We talked about the municipal contracting law in the second session. Well, if you don't follow that, there's a criminal violation involved. Okay, and again, these are easy things to do. All right, it's just sometimes you have to jump through the hoops. They're frustrating, but it's important that we do. Okay. Now, if you happen to win, get a favorable outcome on your case, meaning you don't get convicted, you don't take a plea, probably meaning you're acquitted or it's dismissed. All right, then your township may compensate you for the losses, or the insurance could compensate you, okay? It's pretty rare those things come up, and it's unfortunate to say, but it's usually board members who don't get along, who are then turning to law enforcement because they can't get along, and so they're just looking to ding somebody. Sometimes they genuinely believe there's a problem. Occasionally there is, but it is so rare, okay, because there's not a lot involved here for a person to want to have the desire to do something wrong, okay? Now, clerks, I will point out to you, criminal liability can attach to problems with elections. It is critically important, and this is for everyone, critically important that your elections are managed properly, meaning supervisors get those clerks whatever they need, whatever and everything to get them trained and the resources they need to administer elections. Pay for them to leave for training. Pay for them to take trainings. All those things they need to do, get it done. If they have a deputy, which all of them are supposed to, okay, get that person trained. Have others who are available to help. If they need staff at some point, which some do, get them someone to help them, because it's a serious problem for that person. And they may be trying to do everything right, but it's a complicated area, okay? Clerks, get that training. Okay, we're going to do trainings like this. Your county auditor offers them. The MAT calendar has deadlines. The Secretary of State has resources. It's all out there. Please take advantage of it, and everybody enable those clerks to get that done so that they have no problem and no concern about any criminal law issue, because they're trying to get your election managed. All right. Data Practices. Okay. Data Practices Act says that all data will be open to the public, okay? And all data is public. It's kind of like the open meeting law. This is another element of that Minnesota good government, the blue sky law. I think this is great, right? People can get access to stuff. So there's a chapter 13, that lays out the Data Practices Act and says all government data is public. But then there's another 100 pages of exceptions, and there's some federal laws involved, okay? And the presumption usually being, if you have it, you have to give it away to somebody who asks, all right? And that's different for personnel data. There's a little difference there. But this is a terribly complex law to deal with. The great news about this is it does not apply to townships that are outside the 7-county metro area, all right? Now, if your township is in the 7-county metro, I'm very sorry, All right, this is something you will have to learn and deal with, and you will need to get help from your township attorney. Okay. Those that are subject to it. You're going to have a written policy, and there's sample policies available. You have to have an individual called the responsible authority designated to say, here's our person that gets these and is responsible to get them out. Okay? You can't charge for time to assemble documents. You can charge, I think, a quarter a page for printed copies. Okay? But if somebody wants to come in and look at something, you can't charge them. If they want digital copies, well, that doesn't cost you something to produce. That doesn't take material in the same way. You can't charge something, okay? Now, it amounts to a public subsidy of every person's desire to dig into government records, okay? And that's uncomfortable for some folks. The idea that, well, some people are just rooting around for something, and they literally will ask for decades of information, okay? It's not feasible oftentimes to do that, and that takes great expense to do it. But if you're subject to data practices, your options are very limited, okay? And you will work with a township attorney. I'm sorry, you will have to have that cost, okay? It is a violation of law here. It's a misdemeanor to violate the Data Practices Act. But for the rest of you, you don't need to worry about this as a matter of the law, okay? Instead, though, you need to worry about perception and the possibility of losing your exception. This is a very precious exception, okay? Unless you want to start to learn and make me learn more than I know now, all of these things and exceptions, we need to protect it, okay? You get the exception in rural areas because as the the Data Practices Act was being put together, it was pointed out that townships don't do a lot of the things that cities and counties in the state do. And it does apply to all of them, okay? They have a lot of other activities they manage. But for townships, sometimes you're only managing a few roads. You may not have employees. The public data you have, for example, the things that should be out there are your audit report, the Board of Audit that you do right before the annual meeting in March. Well, that's an accounting of all the expenses and purchases, okay? So that should be already out there and available, all right? That's one reason. The second reason being it's very complex and expensive to deal with, and you don't have staff a lot of times to do that. You don't have somebody sitting there to deal with it. So legislators gave you an exception. You do not have to comply with the Data Practices Act, but instead, our understanding is that townships will try and provide whatever data they can, okay, unless it's protected for some good reason, to whoever asks for it. All right, and I mean anybody. They do not need to be a landowner or a resident, have ever set foot in your township. It doesn't matter if they're a state resident. Not too long ago, we had a company in Florida who was looking to gather data for political purposes. They were an interest group looking to get data out and to fix to represent their point of view, okay? Well, they sent emails out to every single local government in the state to demand data, okay? Well, our townships were able to say, well, we will try to get you something, or I'm sorry, we're not comfortable doing something in particular, okay? So, but otherwise, you try to get data out to them. You always will give them contracts, claims, payroll, but the top line only, the gross. Okay, they are entitled to know what any official and employee makes as a top line. But you should not give out the deductions in a paycheck. Okay, they may be able to see the gross and the net, but it's no one's public business, any of the deductions. Okay, there's going to be tax deductions, of course, but maybe somebody has a garnishment. Maybe someone is paying child support. That is not any business of the public, and you do not disclose it. Now, that may mean you take the check or the paycheck and you redact it, or you provide a report that's already in existence to give them the information. okay? You never need to produce anything new, right? This is only existing data, okay, that you produce or that you provide when asked. You try to work with them, ask when they might need it. If it's a really big request, say, look, I'm not going to get to this full thing soon. What's the most important thing to focus on for now? Okay? Now, townships can charge a reasonable fee. Many townships charge something for copies. They charge something for the clerk or treasurer time to dig into records. Right? But clerks and treasurers, your records should be reasonably organized. And I know that's not true everywhere. I'm aware you are often given a box or a bunch of shoe boxes with records that go back decades, okay? And I know that's difficult. But you may need to go through them at some point or slowly, okay, to try and find things, all right? If you do charge fees for time, keep it reasonable. It really probably should still be a public subsidy to do these, because the concern is if they have a big data request and you give them a bill for $400, they're going to go to their legislator and who's going to say, oh my gosh, I can't believe they charge you so much for this information. That's not right. And every year we have to fight back changes to this law, okay? So please guard it carefully. Give things to people. I don't care if you like them or what they're going to do with it. They could be using it for marketing. They could be asking for the voter, the registered voters. Yeah, they get it. Okay. They could be asking for your contracts. Absolutely. There's no privacy there. Okay. If you're a vendor you're working with says, well, we don't want this given out, say, sorry, we have to give it out. There's no privacy involved here. There's no trade secret in a contract. Okay, payroll. Yeah, of course, it's a public interest what those public dollars are doing. Okay, give those things out as quickly as you can. Now, keep it reasonable. I know this cannot be a full-time job for a clerk or treasurer or somebody who's going to do this. Okay, you may need to schedule it with them. You may also ask for money up front if you're going to charge something, but make that a board decision. This is not a clerk-treasurer choice. This is a board decision. What's your policy? What are you going to do? And then apply it the same to everybody so we don't have liability issues, remember from before, like a procedural problem, like, hey, you didn't follow the same process for that person as you did for me. You damaged me in some way. I didn't get equal protection of the law, okay? So we do these the same each time, all right? Decide those policies up front and make sure everyone understands how they work. Okay, I had a question. Does every clerk, should they have a deputy? Yes. Every clerk and treasurer is entitled to appoint a deputy. Each clerk and treasurer, regardless of whether you are elected or option B, as they say, township, where you're always appointed, you appoint your deputy. That deputy is able to stand in your shoes whenever you are unavailable, meaning they can do all the actions you do. They can swear people in as if they were a notary ex officio by virtue of office. They can sign as the clerk or treasurer at your direction or during unavailability. Okay, and we construe that broadly. If you're just, if you want them to do something, you direct them to do it. Okay, supervisors decide their pay. Supervisors, we strongly advise you ensure they get paid. Deputies need to get paid and trained, otherwise they're of no value to you or the people who appoint them. Okay, send them to training. That's fair game. We love to have deputies in training. One of the common complaints in townships is there's nobody to take our place. No one's clamoring usually to take your place, okay? But if you prepare somebody, set the stage for them by making them a deputy, the stakes are lower, they get trained, they feel more comfortable stepping in at the time that you need them to, that can help you maintain your township and keep somebody ready to step in later. Okay, so please, yes, everybody should appoint a deputy. We have sample forms for appointing in the elections section on the web page. Okay, you'll see a notice of appointment of deputy. The deputy survives with or remains the deputy at the pleasure of the clerk or treasurer who appoints them. So if the clerk resigns, their deputy is immediately done, okay? You don't get to continue keeping the deputy and say, oh, good, gosh, great, we had this deputy in place. So, okay, no, they're in place only as long as their appointing authority is in place. If the clerk or treasurer dies, that deputy no longer has powers if they're voted out, or if they're told, I remove you as my deputy, okay? Each time you do this, okay, you good to swear them in, okay? That's a good practice because they're going to be exercising the office duties as if they were you, so do that for them, okay? And keep doing that each term at least. All right. Another question here. Doing another Zoom meeting with a resident who is a former supervisor demanding, and I got to move this again. Here we go. Okay, demanding the recording the clerk kept to do the minutes, which has been destroyed. There was something stating recordings on Zoom. And here I'm having the issue I had last week where I can only see part of the question, and that even if I scroll, I can't get all of it. So Michelle had this question. So, okay, someone's demanding the recording of a meeting. Townships are able to choose whether or not they want to audio record a meeting. Okay, and you would do this usually for two purposes. One is it's going to be part of the record, and it's going to be retained. Okay, data retention is one of the clerk and treasurer duties, and that thing gets kept forever basically unless you've adopted the data management schedule, okay, data retention schedule. And that would be something, yes, you would provide to people if they want it, all right? But the other reason you could record is for the convenience of the person doing the minutes. And if that is the case, and the board makes clear it is only for that purpose, it's not kept, okay, the clerk or whoever's doing the minutes uses it, takes the recording, and then destroys it because it's the board saying that's not part of our record. Okay, they're effectively saying that's destroyed immediately because it's not becoming part of our record. The minutes are the official, proper record of a meeting. Even if the audio says something different, well, that poses a problem for your minutes. Okay, but legally the minutes are the official record. So Michelle, you do not have to turn this over again, assuming you're not in a data practices jurisdiction. If you're in a data practices, meaning within the 7-county metro, I would talk to your town attorney because I'm a little leery of destroying anything within a data practices jurisdiction, okay, because there's that misdemeanor violation. But assuming you're not there, you can withhold it even if you had it, right? And in this case, you're not keeping it as part of the record. It's for your convenience, okay? And I can't, oh, there we go. There's the rest of it. Thank you. Okay.
Hey Steve, this is Joseph with Seminar Web.
Yeah.
I just wanted to inform you that all you need to do is click on the question and it should expand to its full sentence length.
Well, it does, but I cannot scroll. For example, this is a long one, and I can only get part of the question. When I scroll down, I get the remaining 3 questions at the bottom. So.
Okay. Can you see the full sentence length of Michelle's question right now?
I can see the, no, I can only see part of it. It cuts off where we also have a resolution that says the recordings are only for the, and it stops. So, so Michelle, if you don't mind, oh, there we go. Okay.
Yeah, you may have to increase the size of your Adobe Connect window. It sounds like the window is just too small. So if you expand your software platform to its largest window size, that should help.
Thank you, and for all of you, thank you for my for your patience with my playing with this here. Okay, so Michelle, you have a resolution saying you do it only for the minutes. Fantastic. You are fine. Your board as a group made that decision. You don't have to give those over. Okay. All right. Another question. The clerk treasurer selects the deputy, not the board. Absolutely correct. This is not a board power. Remember, there's powers and duties delegated to each person. Consider, okay, that clerk and treasurer, when they appoint the deputy, they are standing in the shoes of the clerk and treasurer when they do the work. Okay, they have to have complete trust that that person is going to do as they direct them. Keep in mind, the clerk and treasurer do not work for the board of supervisors. I'm sorry, supervisors. You are all elected members. You are officers of the township. Okay, clerk and treasurer are just as much. They work for the voters the same as you, okay? So they have to have trust in their clerk and treasurer, okay? By extension, the clerk treasurer becomes responsible for the actions of the deputy. I would want to know more about it. I sense we're getting into a deeper question. I don't have a answer for that until I know more about the particular situation you're asking about. Okay. Another question. Some clerks and treasurers are not elected but appointed as well, like the deputy. Is this appropriate? Yes, in what are called option B, as in boy, townships, that means the voters have selected to remove the clerk or the treasurer as an elected position and instead make them appointed by the board. So that means the Board of Supervisors can hire or fire their clerk or treasurer as if they were an employee. There's advantages to that. Okay, I won't go into all of them, but basically you do it when you have issues and they can't get along, okay, or you cannot find a clerk or treasurer to serve and you need to go outside the township, because once they're no longer elected, they no longer need to be a resident, okay? And that's option B. Some townships have adopted it for various reasons. Downsides being now you have an employee board of supervisors. It's a mixed employee and officer, and you have to understand how to work with that person, okay? But that appointed clerk treasurer still appoints their deputy and has control of the deputy as a matter of law, okay? The supervisor control over pay is persuasive and all that stuff too, okay? All right, may a town prohibit a member of the public from recording a meeting or hearing? Absolutely not. Minnesota is a one-party state. Anyone may record anyone else without their knowledge in a public place. We're not talking their home here, right? We're talking public place, and of course your town meetings have to be in a public place or open to the public to hear. So if they audio or video record you, that is their right to do so, okay? And your right to do it back to them, all right? So that's fine. Let them do it. Not a big deal, okay? Legally, they can do that. All right. How long does the township have to keep records for? Kelly, indefinitely, unless, forever, okay? Unless a statute directly tells you otherwise, and there's not many of those, all right? Or the township has adopted the Town Record Retention Schedule, which is something produced by the State Historical Society to say, well, we have all these categories of records. As a rule, we understand some of them may not need to be kept forever. We can change the default rule. So the town board can adopt that retention schedule, and they may even modify it, okay? So you should look at it, and it's a little confusing. There's a lot of stuff in there, and some items fall into different categories. And when that's the case, you as a board have to decide how long are we going to keep this for. And then you make it reflected in your policy, and now you may, as a clerk or treasurer, go through and properly go through document destruction. And with that, you still have to do some forms related to, here's what we destroyed. So it's all a paper trail, that procedural thing, okay? That protects you because you do get into disputes about what was lost, okay? All right, I think that is all of our questions. We're coming close to the end here. We have one more, okay, one more. Back to C6000, if a board member is delegated and approved to serve as a road supervisor or manager, I'm going to take the road manager. The board should do this every year. Okay, a road manager is not an employee. So you can, as a board of supervisors, appoint one person to be the administrator, like the manager of the staff or the contractors. And if that person is just managing those people and taking in information from the public about road conditions and then directing those who do the work to go do something, that's not manual labor. That is within the elected duty of a supervisor. No C6000 resolution would be required, okay? Now, if they're going to do operating, manual labor, yes, you're correct. Do this every year for that person, and the affidavits, make sure they do that each time, okay? All right. With that, we have reached our final slide. Thank you for doing this training. We find it really important, and we hope you have a lot more knowledge about the basics of township office. I don't want you to feel that this covers it all or that you can learn it all in a short time. I've been doing this for 5-6 years now, and I still have to look up things and find answers, okay? And please use the resources you have available to you. And as you think about this and as you work through this, there's going to be the laws that you have to deal with. We'll try to give you the counsel on that. And there's always the politics to deal with, okay? And we're less help on that because that's people's opinions and feelings, all right? You have to maintain relationships. You have to move to within your township and outside, okay? And that's this last slide here. Once you start destroying relationships, you cannot move forward. This comes from a mayor, okay, a city mayor. We're quoting, because that city listed here wanted to annex part of a neighboring township. This was very controversial. It's a big problem among towns and cities, okay? They went to the same churches, the same schools, their kids knew each other, their families, okay? The mayor decided eventually if they did this, it would create so much of a problem in their relationships in their community beyond their city and township borders that it wasn't worth it just to expand the city borders. And they didn't do this. Okay? This is a good model to use.